and individual relationship. Identify an administrative law relationship generally and either a general or an individual relationship specifically in a factual situation. Right. The outline of this learning unit is as follows. 2.1. The characteristics of the administrative law relationship. 2.2. The distinction between the general and an individual administrative law relationship. 2.2.1. The general or objective relationship. 2.2.2. The individual or subjective relationship. 2.3. Conclusion. In the learning unit, we pointed out that one of the key issues in administrative law is the exercise of state authority. State authority, in a nutshell, refers to public or authoritative power exercised by a person or body in authority where such power affects the right or interests of another person. The person in the lesser or service and position. This does not suggest that the person in such position is without right. It simply means that he or she is subject to state power or authority. We also mentioned in the learning unit 1 that one of the distinguishing features of the law is that it regulates relationships between at least two legal subjects. A legal relationship is one in which two or more legal subjects enter and it is governed by law. When one of these legal subjects exercises state authority or power over the other legal subject, the relationship created is known as a public law relationship. One party has a state authority which he or she may exercise in relation to the individual who does not have such authority. Before considering characteristics of the administrative law relationship, look at the following activity to see whether you can recognize an administrative law relationship. Activity 2.1. Reread scenario 5. The story of the buying of cars by Department of Transport. 6. The story of Irene. And 7. The story of the health official. These scenarios set out in the learning unit 1. Are you able to recognize any legal relationship based on authority in these scenarios? Write them down. Don't worry about the reasons at this stage. Could you see the table such as the one below? We will use story of John in scenario 1 as an example of what we had in mind. A relationship of authority. Yes, someone exercises state authority, the principal of the school. Person in subordinate position, John. And so on and so forth. Okay. In law, a distinction in general drawn between public and private law. Public law regulates the organization of the state and the relationship between the state and the individual. Public law is further concerned with the exercise of state authority by the government and deals with the relationship where one of the parties is always the state as bearer of state authority. The other party is a private person whose legal position is subject to the state discretion. Again, this does not mean that the individual does not have rights or that the state can exercise its authority whichever way it likes, which is where administrative law comes into the picture. The public law relationship is therefore a vertical relationship and a relationship between someone in authority, a subordinate or lower ranking individual. Private law is concerned with the relationship between the individuals who are on an equal footing. In other words, it is a relationship of equality. You may well ask, but what about the relationship between the parent and the child? Note that the relationship is not founded in the state authority of the parent, and for this reason, the relationship falls within the sphere of private law. The private law relationship is therefore a horizontal one, individual versus individual. Okay, we move on. Relationship of authority. It is 5. Someone exercises a Department of Transport, person subordinate the car dealer, the subordinate position. Okay, scenario 6, scenario 7. Okay, note that all 3 of these scenarios fully explained in Learning Unit 1. It was easy to recognize the person exercising authority. However, often the same scenario produces a number of different administrative law relationships. The ability to identify this relationship is the first step before explaining why they qualify as subjects of such a relationship. 2.1. Characteristics of the administrative relationship. It is important that you grasp the characteristics of the administrative law relationship before you continue with the remaining learning units. For assessment purpose, assignment and examination, you should be able to explain this relationship for no less than 8 marks. 1. At least one of the legal subjects must be a person or body who exercise power. 2. More important, the position of power must be held by a person or a body clothed with state authority and who is able to exercise that authority. In other words, the authoritative person or body, organ of the state or natural or juristic person must have the power to prescribe, restrain, allow the other individuals or juristic persons to act in a certain way. The authoritative person uses the authority to compel the other party to such in a specific way. Moreover, such exercise of power may affect the rights and interests of the person in the relationship, leaving such person in a subservient or subordinate position. Now that we're familiar with the definition of the relationship, consider scenario 1 explained in unit 1. When we think back of the story of John, scenario 1, the principal most certainly is clothed with authority and has the ability to exercise power over him. The punishment meted out of John to suspend him from school affects or impinges on John's right and interest, e.g., to attend school, to receive education and training, or even to take part in sport or other school activities. We have seen in the administrative law relationship, scenario 6 and 7, that the administrative law relation can exist. The person who exercises authority and private individual in the subordinate position, scenario 6, but also between the person who exercises authority and the lower ranking official in the same department, scenario 7. In other ways, a relationship may exist between government authorities inter se. We could explain the situation as follows. The party in the lower ranking or subordinate position may be another person under the authority of the superior official. For example, the health official of our story is scenario 7 is under the authority of the Director General of Health. The relationship between them is indeed one of the authority. After all, the superior government official or body exercises its authority over the lower ranking official, and the relationship remains in a public law relationship. The servient official is compelled to submit to the authority to power exercised by her superior. Please note, Relationship between administrative bodies themselves may be further complicated by the concept of delegation of power. This will be discussed in Learning Unit 7 activity. First, make your own summary of what we have learned so far about the administrative law relationship. Use the following headings. What is an administrative law relationship? What is the characteristics of the administrative law relationship? Then read the decision in Annexure B, the Adm African case, again to make a list of possibly administrative law relationship in the case. The subject of the relationship. This is self-evaluation activity. Use the information given earlier in this learning unit guide you through the answer. 2.2. The distinctive between the general and an individual administrative law relationship. Within the administrative law relationship, we distinguish between the general or objective relationship and the individual or subjective relationship. In addition to you being able to explain the characteristics of an administrative law relationship for about 6 to 8 marks, you should also be able to explain the distinctive between an individual and a general administrative law relationship for about 10 marks. Take this into account as you read and carefully study the following. The general or objective relationship. In the general or objective administrative relationship, the legal rule governing the relationship between the parties apply to all the subjects within a particular group. These rules apply impersonally, that the general and the objectively and non-specifically, and not to a particular identifiable legal subject. Note that a particular group is not the public in general. A group must be confined to a certain class of persons, such as refugees, asylum seekers, or even defined group of persons who reside in a certain area. The general relationship is created, changed, or ended by legislation, including delegated, subordinated legislation. That is, by general means. In other words, a general administrative law relationship cannot be created, changed, or ended by, for example, a decision of the Director General of Home Affairs. For example, when you recall scenario 2, see Learning Unit 1, and the story of Theodore, refugee, the provisions of the Refugee Act 130 of 1998 and the regulation made in terms of the Act are applicable to all refugees entering or residing in South Africa. It is therefore an example of general administrative law relationship between the refugees generally and the Department of Home Affairs, the department responsible for dealing with such matters. 2.2.2. The individual or subjective relationship. In an individual administrative relationship, legal rules apply personally and specifically between the parties. In other words, the legal rules apply to specifically identifiable legal subjects. The content of the individual relationship will vary from case to case. Individual relationships are created by individual administrative decisions. Individual relationships are therefore not affected by new general legislative provisions unless the amending act specifically states that it affects the relationship. The presumption is that any existing individual relationship is not affected by amending legislation. An example of presumption against retrospectivity. Note that presumption is that an existing individual relation is not affected by amending legislation. An example of the presumption against retrospectivity. Note that presumption and their role are dealt with in the interpretation of status model. In Theodore case, see scenario 2 of the learning unit 1. The decision to withdraw his asylum seeker permit, allowing him to stay in South Africa, is an example of an individual relationship which exists between Theodore and the Department of Home Affairs. This decision by the department only affects Theodore, not refugees general. Scenario 8. It is 1991 and the Reservation of Separate Amenities Act 49 of 1950 has been repealed. However, the municipality of Old Town makes a decision that only white men may visit the public park in the center of town. Women and the other residents of the town are not permitted to do so, nor are visitors to the town. Note the facts of the scenario loosely based on the case of Jacob Walks, 1992, 1 SA 521, paragraph A. Scenario 8. Old Town Municipality Separate Amenities Act repealed. Scenario 9. National Students Financial Aid Scheme. NSFAS is a statutory body regulating the distribution of bursary loans for teacher training to students. SEPO applies for a loan to this body, but the application is refused without any reason being given. Okay, let's go to activity 2.3 now. Are there any administrative relationships recognizable in the two scenarios? Yes. If so, write down whether they are examples of individual or general administrative relations. Explain why. In scenario 8, we find an example of the general administrative law relationship between the municipality and all its residents. In scenario 9, we find an example of the general relationship between NSFAS, the statutory body regulating and distributing the bursary loans to prospective education students. However, an individual relationship is recognizable in the relationship between NSFAS and ZEPO when he applied for a loan. Conclusion. In this learning unit, we have explained the features of administrative law relationship in general and two kinds of administrative law relation we find and how to distinguish between these relationships. In the next learning unit, we examine the legal subjects and administrative law, that is, the organs of the state and natural or juristic person exercising state authority over others, as well as the persons in subordinate position whose rights and interests may be affected by the exercise of such authority. Danko, 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 danko.